Well, good afternoon, everyone. As Brett said, I think you're truly brave to be here on a Sunday afternoon at this time to listen to people speak about claim construction. Brett said it's a dry subject. I would also add to it that it's also an esoteric subject, one which leads to sometimes very, very difficult conclusions, and one which I think people even who practice in the area don't necessarily understand that well. Having listened to Brett's talk, he's kind of left me in the position of being the respondent in an appeal. So I've made copious notes of what Brett said, and I may stray from my slides at some point to detail where Canada is either the same or different, but by and large I can cut my talk short by saying what he said. But because of that, I'll present my subject in a little bit of a different way. We do share a queen, the same queen as Australia and unfortunately as England, but she is our queen. Our Patent Act was actually substantially overhauled about, oh goodness, now I'd have to say, what, 20 odd years ago. Time's really moving fast. So we've actually addressed the subject in a bit of a different way because our law, unlike Australia's, has advanced a bit more than what's in the UK. The topic I was originally going to talk about, which is listed in the materials, says, I believe it's something like claim construction, is there an elephant in the room? And I need to clarify why I chose that topic, because obviously there's people of different nationalities here and different cultures, but two things. One, it's not about patent claim construction, it's about patent construction, because in Canada there's been a lot of activity in the Supreme Court, and we've gone way beyond just looking at the claims, and I'll detail that a little bit later. But the elephant, I mean, why did I mention an elephant? And in North America, there's an expression, there's an elephant in the room, and it's an inconvenient topic that people don't want to talk about. So a very good commercial on our television right now where there's a person who's drunk a fair bit of alcohol at an event, and he's grabbing his car keys to leave. And this big giant elephant appears in the commercial and said, you need to talk about this, you can't just let it go. And I think that's, certainly in Canada, there's an issue with respect to claim construction. There's an issue with respect to the words that are chosen in claims. And there are issues with respect to how specifications and disclosures are put together. And often, I think we as a profession don't talk about that, but certainly given what's happened in our Supreme Court recently, and I'll look at the case at the end of my presentation, I think it's become really, really important that, certainly when you're drafting a disclosure, that it be clear and unambiguous. And you're not going to get away with much anymore, that unless you disclose what the invention is and you disclose what the invention is very clearly, you're going to be held to account if you stray from that. So anyway, starting with my topic in general, obviously, India is a huge country. It was pointed out to me at dinner the other night that population of Canada is about the same as Bombay. So why would you really care what's happened with respect to patent law in Canada? Well, the proposition I would put to you is you might want to care because it's a highly developed topic in Canada, claim construction and patent construction in general. It's been considered by our Supreme Court numerous times. And perhaps I'd just better outline briefly for you how cases arrive at our Supreme Court. In Canada, we're purely a federal system. So while provincial courts can hear issues of infringement, they cannot rule on issues of validity. And because of that, nobody really litigates patents in the provincial courts. It all goes to the federal courts. And because of that, they've developed a fair degree of expertise in this topic. So you bring your case in the trial division. It wends its way, obviously, from discoveries to hearing. You can then go to the appeal division. And then beyond that, the court of last resort, so to speak. Sorry, I'm just trying not to trip on these things. The court of last resort is the Supreme Court of Canada. And you can only get to the Supreme Court of Canada if you can prove that there is a question of national importance. And basically, national importance is judged by our court as something which affects all of the people in Canada. And it's a pretty difficult test to meet. I'm preparing a leave application right now, and it's not easy to do. So the fact that we have, I'll reference probably 5 cases in my presentation that have been heard by our Supreme Court, says an awful lot about how they view construction issues as being very important. So most recently, we've had 3 cases, the so-called trilogy of cases, and those are the cases which basically gave us purposive construction. And we haven't adopted Catnick the same way that Holders Bowler. Well, I'm not sure if I understood fully, Brett, but I think you guys follow it fairly closely. We have a modified approach to Catnick. So we have those three cases. And then just recently, last November, we had another case in the Supreme Court, which, as I said, I'll talk about later on. But that gives us what, I know it sounds a bit flaky, and it's not, maybe it should be Californian as opposed to Canadian, but that gives us the holistic approach, wherein when you look at questions of validity and infringement, you just can't look at the issues, for example, validity or obviousness or sufficiency of disclosure or sound prediction in isolation. We now have our Supreme Court saying that you need to look at it as a whole, that you look at the claims, you look at what is being claimed or what is being attacked in this holistic way. So you don't narrow out and parse these things into a single element test. You look at the question as a whole. So anyway, going back, so there's always an emphasis on the claims, and that's been the traditional approach with construction. So why such an emphasis on the claims? Well, it basically sets out the monopoly of what you're claiming, and it's specified in our Patent Act that it's the specification must end with a claim or claims defining distinctly in explicit terms the subject matter of the invention, i.e. the privilege that you're claiming. Australia, similar provision. UK, similar provision. So all of this, us as patent people and people who draft patent applications, it becomes really important to consider the kind of language that we use when we're drafting an application. Normally the procedure goes pretty quickly, that we draft the application for filing in our home or national offices. That application gets filed. Soon after that, obviously, you can either go internationally with your PCT or you can file a national application. And then once those applications are ongoing, now you can move with PPH. So, Patent Prosecution Highway. My experience with that is only with the US, but what I found in Canada, trying to rely on allowed US claims, is that the Canadian examiner will bump you out of the track pretty quickly if you start straying from the wording that's used in the US claims. So to me that presents a bit of a problem, because you might not end up with the same scope of protection in Canada that you could have if you had gone out of the PPH route and followed the national route in Canada. So, it's great to talk about, us filing these applications, obtaining claim sets, and thinking that they have the same scope of protection, because they probably don't, because things are going to be determined in different countries in very different ways, and that's going to be because of the different legal tests that are used, but also because of the different languages and interpretations which are placed on those words that are used. That was kind of driven home to me recently when my son was showing me a good trick you can play with Google Translate. And while I would never ever suggest that anyone in the patent profession use Google Translate, we kind of washed a phrase through it. I think we washed it first into French, then into Italian, and then back into English. And the English made no sense whatsoever when it came out. So that kind of just shows you that you have to be very careful about not only the words that you're choosing, but how they're being translated and rendered into what are going to be the claims which are your legal monopoly, or I should say your client's legal monopolies. All of this matters because a court's going to look at what do these claims cover, and usually what do these claims exclude. Now, I mentioned that in 1989 we changed our Patent Act, so we went from a first to invent to a first to file system. And then not too long after that, we had the trilogy of cases in our Supreme Court. I haven't referenced them here, and if anyone's interested, I can tell you what they are. But what they did was switch us from an American system of assessing or of applying claim construction, followed on by tests for infringement, to what was a modified system which imported a lot of the findings from the Catnick case in the UK. So previously, when you tested for infringement in Canada, I'm jumping ahead here a bit and getting away from construction, but it was basically literal and then substantial infringement. So it was pretty easy to conduct an analysis. You basically went through the claim. It was almost like a checklist. If you had every element in there, well, it either infringed. If you were lacking one, it didn't. Then if when you were looking at the accused article, if something was done slightly different, then you moved into the doctrine of equivalence, which is very much an American approach. So basically, substantially the same structure, working substantially away, substantially the same result. So it gave you a fair bit of latitude to move away from what you had actually specified in the claims. Again, this was kind of highlighted to me a couple of weeks ago when I had an American attorney ask me for an opinion. And I forget precisely what the device was, but say for the sake of argument, we had a truck consisting of 4 or more wheels. He came to me and said, well, the other side's got a truck with 3 wheels. Can we get them in Canada for patent infringement? I mean, the case, the claim clearly said, 4 or more. He's coming to me and saying 3. And I said, well, can't really run that in Canada. And he said, well, I thought not, but we could certainly run that argument in the US, and we could stand not an unreasonable chance of succeeding on it. So, to me, that really drove home the fact that even anybody came to me and asked me that question made me wonder about the US system a bit. Not to disrespect the US system, that is, though. So in Canada, and I'm not going to belabor Katnick, as Brett's gone through it fairly well, we have a one-step approach to claim construction. The court examines the claims purposefully to decide what's essential and what's not. And then obviously if there are substitute elements in there, you avoid infringement. Like Brett said, that it doesn't let you leave elements out. So we very much like Australia like that. Again, we've got certain canons of construction. These are basically, this is a list that comes from the trilogy of cases that, Canada was adopting new law at this time. And I think the judges felt it very important to set out what the canons were. That a judge, when he's assessing infringement, and I say judge because Canada, like Australia, only has judge trials. No such thing as a jury trial as in the US. So these are the kind of things that a judge has to turn his or her mind to. Obviously, as with Australia, construction precedes any consideration of validity and infringement. It's conducted in isolation. Again, very hard to do, and obviously these cases arrive at court, and the judge has to basically clear his or her mind and just look purely at what the words of the claim say. Any ambiguity or any question then can turn to what's in the specification to try and figure out and assess what that particular word or words or phrases mean. It's a pure question of law for the judge. And all of this obviously is done. It's very easy, obviously, to turn one's mind back 10 or 15 or 20 years. Well, not 20 years, because by then that patent may have expired. But turn one's mind back to what the date of the publication of the patent was. So again, pretty difficult canon to follow, but one has to kind of put one's mind back to the certain date when the publication of the patent occurred. Again, construction is for the court and viewed through the spectacles of the skilled person in the art. And Brett went through what the skilled person of the art was, so I won't belabor that. Construction must be purposive, neither benevolent nor harsh. Again, judge can seek to try and find infringement, even though he or she has not looked at what the infringing device is, nor try to defeat the case in any way. Judge has to look at the whole of the disclosure in the claims, claims read in an informed, purposive manner. Now, probably one of the most important canons of construction in Canada is intrinsic evidence. You can have intrinsic evidence, and that intrinsic evidence basically is anything that you have said in the disclosure and or the claims. But you can't go outside of that and have the inventor lead testimony as to what the invention is, or what the invention was supposed to be. It has to be found purely and squarely within the 4 corners of the patent. As with Australia, and contrary to the US, no file wrapper estoppel. People have tried a few times in Canada to do it, and judges will not have anything to do with it. That they view the patent as speaking clearly as to what the invention is and what the claim monopoly is, and it stops there. You can't go back to try and either correct something or to introduce some statement which has been made in the patent office to narrow the scope of the claim or broaden the scope of the claim, either way. Again, finally, the last one. There are other ones, but these are the key ones that were mentioned in the cases. No recourse to spirit of the invention, which again was in our law pre the trilogy of cases, but now is gone. So really, it comes down to an identification of non-essential versus essential elements. The test is that, based on common knowledge, would it be obvious to a skilled reader that variation of a particular element would not make a difference in the way the invention works? So it becomes very much a question for the court to put the judge to put him or herself in the mind of the skilled person when assessing this. So the goal of the analysis really comes down to the court reads the words that the inventor chose, i.e. the claims, and has to read them in a way that's sympathetic to what the inventor was trying to accomplish, and which is implicit in the text of the claims. So the key is the identification of particular words or phrases in the claims that describe what the inventor considered to be essential, and obviously, if the essential elements are left out or not in the infringed device, then no infringement occurs. So, all of this kind of then goes back to how do you choose these words as patent people? What do you do? Because language is really imperfect at describing complex structures. I might have some argument from a chemical friend of mine in the audience that maybe language does describe chemical processes very clearly. But if you're drafting claims to mechanical devices, it can be very, very difficult to come up with a word or a series of words and phrases which really describe something accurately and which you hope at the end of the day will catch an infringer. So, given that it's late in the afternoon, I thought I might put up a few silly examples to look at. But, one of them's mouse. If you mention a mouse in a specification, well, that could be a rodent, but it also could be a computer device. Same thing with a horn. It could be an animal horn or a musical device. And all of this kind of, particularly for those who practice in the English language, as opposed to Icelandic or French, becomes a rather interesting question, because the English language evolves really, really quickly. And a friend of mine told me that the term for that is semantic change. But we have a lot of words in the English language which change or even disappear. So I put a few of them up there for you that I was told that at one time impact, for example, medicine has had a huge impact on humanity, can be a noun, but it really, it became a noun, but it really began as a verb, to pack in or to agglomerate. The one I really liked that was given to me was the next one, which was the new technique of adimpletes the cans with milk through injection. Well, it turns out that adimpletes is no longer a word in the English language. It's viewed by the dictionaries as extinct, so I hope nobody's using that in their drafting. Again, you have regional differences in words, particularly with the US, the UK, and Canada. And again, something very, very important to be aware of when you're drafting claims. So that was kind of the elephant in the room, that people don't really necessarily understand or appreciate that these words have variable meanings depending on culture, depending on where you are, and how you're putting the claims of the application together. In Canada, we use a very similar structure for claims where we have the preamble, the transitional phrase, then the body. That's preferable to us, and we don't like the European way of drafting, because the European way with the characterization clauses really ties you in, because you have the novel elements which follow after the transitional phrase. And our courts would look at that and say, well, you've identified the essential elements for us from the get-go, so you're stuck with that. You can't argue that some of them are non-essential. So generally speaking, in Canada, when we file applications, we often take that language out, as we also do with numerals, because obviously in European practice it's very common to put reference numerals into the claims. We have court decisions which say that's restricting, that if you refer to a particular element by a number, you're stuck with that. So to get a broader scope of protection, we take the numbers out and we switch away from the European characterized type of description. So in Canada, we actually do have a case. I think Brett's on firm ground when he says that comprising includes but not limited to. That was actually judicially considered in Canada and found to be a fair description of the word. Wherein, unfortunately, that's not so clear in Canada. That, again, we have a case that says it's probably not a good term to use when you're assigning a performance measure to something. So if you say wherein, very much like for that Brett met, that you're kind of tied into what it does. So if it does it in a described manner, you're stuck with that. And this particular case where wherein was used was for a pharmaceutical. It was actually for a dissolving tablet, and it described the rate of dissolution and the method of dissolution. And unfortunately, what they were trying to get at involved a different method of dissolution, and the court said, no. If you said wherein, you have to go with that. I mentioned the characterizing clauses already. Again, we have a number of interpretive rules. For example, about. By the way, these are all terms which aren't good to use in Canada from here. For example, an indicator comprised of about 40 to 50% of the surface area of said note. This is obviously talking about a banknote and an anti-counterfeiting indicator which can be applied to it. You can't say about. You will get a rejection from our patent office on that for a lack of clarity or indefiniteness. So it's not a good term to use. Same thing with substantially, an indicator substantially covering the surface of said note. Again, what does substantially comprise? Now, the reason I mention these is you can then, sometimes these phrases slip through and end up in an issued patent. If that happens, you're then stuck with arguing in the court as to what it really means. And again, you're then back to the skilled workman. What would the skilled workman in the art consider to be substantially covered? What would they think of comprised, of about? So, you don't want to be there. It can cause difficulty for you. They don't like phrases in Canada in claims like and or. And again, I've got another description there. Said indicator is a phosphorescent dye and or a magnetic strip. The problem with that is the examiner says it leads to too many embodiments of the invention, because he then has to consider that when it's a phosphorescent dye alone, when it's a magnetic strip alone, or when it's a combination of both of them. So unfortunately, what you have to do in cases like that is separate them all out into separate dependent claims. So I guess the theme of this is that a properly drafted disclosure really allows you to address everything at the outset, to cover what the words actually mean, what the phrases actually mean, and to leave you with full support for the invention. This is where the next element comes into play in Canada, and that is now the court is starting to look at what the nature of the invention is. The patent needs to be examined as a whole, and that includes the claims and the disclosure. From that, they can derive what the nature of the invention actually is. This all came about from a pharmaceutical case where they had challenged the case for insufficiency of disclosure, sound prediction, obviously challenged on prior art as well. And the trial judge in that case said, well, if I look at the patent claims will fail. There was one claim to a compound that failed because it wasn't fully disclosed in the disclosure. It was actually a hypertension medication. And he said, well, generally that class of compounds is disclosed, but the specific compound isn't disclosed. He said, had I been able to assess that the invention which was derived here was for a hypertension medication, I would find sufficient support in the disclosure for that particular compound. But because of the pigeonholing of arguments, he said, I can't do that, and therefore, the claim has to fall. That was then picked up on by, most recently, by our Supreme Court. This is the Teva and Pfizer case. And what they have said in that case, and I'm going to look at it in more detail in a moment, was that no. You look at what the invention is as a whole, and then look at that, whether or not that is then supported by the claims. So this, for us, has huge ramifications for sufficiency of disclosure, and I would also think for sound prediction. So again, just to deviate for 1 sec, we don't, in Canada, we don't have the Markman type hearings. We basically go straight to trial, and the construction is conducted at trial, and you then move on to the questions of infringement and validity. There was an attempt a few years ago in Canada to run a construction question through as a summary judgment motion. Court came right out and said, we're not doing it. So again, we're back very much in line with the rest of the world, and unlike the United States. So anyway, at this time of the afternoon, I thought, forgive the pun, that we might need a bit of uplifting. So I thought we could talk about the Teva case. And this case deals purely with sufficiency of disclosure. So this was for the, obviously for the Viagra medication. And it was heard by both a trial division, heard by the Court of Appeal, and then ended up in the Supreme Court. But basically, Claim 1 in this patent listed a formula which produced over 260 quintillion possible compounds. Now, I can't get my mind around how many compounds that is. They then treat it down to, in Claims 2 to 5, for smaller ranges. And it wasn't until you hit Claims 6 and 7 where the actual compound that worked was disclosed, and that obviously is sildenafil or Viagra. If you go back to the history of this invention, in 1991, Pfizer was conducting trials for an angina study and also for hypertension, and they noticed that the drug they were testing had some unfortunate side effects. They then ran a limited trial to see whether they could repeat these side effects, and of course the side effects did occur again. And in drafting the patent, they didn't test any other compounds or make any other compounds. They went right to what it was, and that was sildenafil, and filed a patent application. But in that patent application, it covered 260 quintillion variations. They did kind of put the reader of the patent in the direction of sildenafil, because they did list it under a series of either preferred, more preferred, or especially preferred. They did at least list it under especially preferred. But they didn't specify that it was sildenafil. They just said that one of these especially preferred compounds is identified as sildenafil. It obviously went through trial, it went through Court of Appeal, and it was upheld. But it wasn't until it hit the Supreme Court of Canada where they said, no. What you've done in this case is you've taken a compound. You knew what exactly it was. You have it listed in Claim 7, but you made no disclosure of it in the disclosure. So what you've basically done is you've committed a bit of a fraud on the public, that an ordinary workman or anyone looking at that patent couldn't figure out that it was sildenafil was the ingredient that worked. And because of that, you're not entitled to a monopoly. And it took our profession in Canada quite by surprise, because what they've come out now and said is that, no quid, you haven't properly disclosed what the invention is, therefore no quo, no exclusive monopoly, and your patent's being deemed invalid. So going forward, I think this really highlights that it's really, really important to specify in the disclosure exactly what the invention is and how you derive it. In closing, it was kind of funny because the next morning I pulled out the Globe and Mail newspaper, which is a major newspaper in Canada. Viagra had a huge one-page ad which said something along the lines of, the price of Viagra is now causing a lot of sleepless nights. So anyway, with that comment, I'll close and thank you.